Hello and welcome to this session in which we will discuss the elements of the contract. In the prior session, we looked at how contracts are formed and we discussed the express contract, implied in fact contract, implied in law contract, unilateral contract, bilateral contract. In this session, we're going to be looking at the elements that makes the contract enforceable. And we touched upon those elements very briefly, and those are: we need an offer and an acceptance. The offer is made by the offeror and the acceptance is made by the offeree. Basically, they have a mutual assent, basically mutual consent. They have a meetings of the minds. Exchange of value, there's an exchange of consideration between the two parties, and there's no defense to the contract. No reason for the court not to enforce the contract. In this session specifically, we will going to be looking at element 1 and element 2. And we're going to break it into looking at the offeror first, the offer, then at the acceptance. Then we would look at the various factors of the exchange of value. We would look at item 3 in a separate recording. Let's go ahead and get started. Before we proceed any further, I have a public announcement about my company, farhatlectures.com.
Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today.
First, we have to have an agreement, a mutual assent, an offer, and an acceptance. So this is the foundation for any contract. Two parties meetings of the minds, agreeing to perform some sort of an act. This means that both parties agree to the same terms at the same time. We have an offer. An offer is a proposal from one party, the offeror, to another party, the offeree, that is serious enough to be legally binding. And again, this contract could be express, oral, written, based on conduct, so on and so forth. This is what we looked at in the prior session. Now, it has to have a reasonable person believe that the offer is serious. Why? Because sometimes statements made in frustration or just are not really an offer. For example, if someone is upset because their favorite team lost the game, say, I would sell my car for $1 right now. Well, that's not really a serious offer because it's not a genuine offer. A reasonable person will not do that. A reasonable person would understand that the statement is an expression of frustration, not a serious intention to sell. Therefore, the offer must be clear enough that a reasonable person would understand it's a genuine offer. How about advertisement? Is advertisement as an offer? Well, advertisements don't count as an offer. So what is it then? It's an invitation to make an offer. So when you see an ad, they're asking you to make an offer. So general advertisements are usually not considered offers, but more like an invitation to make an offer. Come down and let's talk. Now, certain advertisement, they're very specific. Like, for example, the first 5 customers can buy this coffee maker for $1. Well, if that is the offer and you are one of the first 5 customers, then yes, this is an actual offer because it's a specific. This is a real offer. An offer must be definite and certain. For an offer to be considered valid and form the basis of a contract, of an enforceable contract to be specific, it must be definite and certain in its terms. Now, how definite and how certain? The level of that depends on the type of the contract being formed. What do we need to discuss here? We need to discuss the sale of goods versus sale of services. Here we have to differentiate between the two. For the sale of good, if you make an offer, generally such offer need to be primarily specify the quantity of the goods involved. For example, an offer stating, I will offer to sell 100 widgets is often sufficient if it's for the sale of good. So the court can fill the rest of the contract, like the price, location, time, and performance. In other words, for a contract for the sale of the goods, it doesn't have to be specific in terms of price because the court can resolve this the location, the time of the performance, and delivery. So simply put, for the sale of good, all what you need is the quantity, and the court, if need be, will make the contract enforceable. Now, better off have everything, but the point is, for the sale of good, definite and certain does not mean you have to have everything. However, we mentioned this in the prior session, that the sale of good deals with what? Deals with the UCC, Uniform Commercial Code, the sales article. That's okay, we can live with that. However, contract under common law, and here we're dealing with services and real estate. Here we have to be definite in terms of the terms. And this would include the identity of the offeree and the subject matter. We have to clearly identify who's being made the offer and what is the contract is about. The price be paid for the goods and services. This must be specified, or at least we can easily determine. The time of the performance, when goods or services are to be delivered or performed. The quantity, how much of the goods or services are being offered, and the nature of the work. If it's a services, we have to look at the nature of the work, a description of the work of services provided. Now, when we said only the quantity needed for the sale of good, we're gonna clarify this later on when we talk about the sales of good under the sales article of the UCC. Let's take a look at this example. Emma offers to hire Leanne to design a website for her services. So what type of a service is this? Is this a sales of good or sales of service? This is a service to build a website. And she says, I need a website and I will pay you what I think it's worth after it's done. Well, in this scenario, what's missing here? So if it's a service, we have the common law, and under common law, you have to specify the price. Is the price specified here? And the answer is no. It's a crucial component to have the price in this contract. The absence of a clear, agreed upon price means that there's no basis for a mutual assent on this critical aspect of the contract. And without it, the contract cannot be considered valid and enforceable. Simply put, it's not a valid and enforceable contract. Therefore, Leanne cannot reasonably expect this offer expecting legal protection or enforcement, as the terms are too vague and leave significant aspect of the contract undecided. Now let's go from the offer. So simply put, for a service, you have to have the definite terms. Now, for an offer, it has to be accepted to have a valid contract, because you need two parties. Someone is offering something and the other one accepting. Now, we're going to talk about termination in another session, but let's now assume the other party accepts. Acceptance is when the offeree agreed to the terms of the offer. So it must correspond to the offer terms without any changes. What does that mean? It means you have to agree according to the agreement. Acceptance must be unequivocal to all terms of the offer without any changes, known as the mirror image rule. So like when you look at the mirror, you see yourself. You have to accept the offer as is if you are accepting. And how can you accept this? Well, method of acceptance, the offer may specify how the acceptance should be communicated. So whoever is making the offer, they can add specific condition if they choose. That's their offer. So be careful when you have those multiple choices. Now, if not specified, any reasonable method, including conduct, can be used to accept the offer. But if the person making the offer says, I would like you to email me, then you have to email them. If they want a certified mail, then you have to use certified mail. If they specify, you have to follow that specification. Communication. Acceptance must generally be communicated to the offeror. You have to communicate to them. In some cases, like unilateral contract, what you have to do, you have to act under those circumstances. This is how you communicate. And how about timing? Well, you have to accept before it expires or within a reasonable time. Let's take a look at the second element of the contract, and that is consideration. For a contract to be enforceable, there must be some sort of a consideration, an exchange of two things. Something of a legal value must be exchanged, and we're going to talk about what legal value is between the party, and the exchange must be the result of mutual agreement or negotiation. There's some sort of a bargaining going on back and forth. Without these elements, a contract typically lacks the necessary substance to be legally binding. So we have to have some sort of a legal value being exchanged. So what is a legal value? Something of a legal value given by each party. This means usually you're exchanging money for something else, but it doesn't have to be money. This means that each party in the contract must contribute something valuable. Well, because I'm giving you something, you're going to give me something in return. The value does not have to be necessary to be monetary, so we can exchange something other than money. It can be a service, a physical item, a promise to do something, for example, stop smoking, or even a promise not to do something that one has the right to do. For example, not to sue you, not to pursue legal claim. That's a valid legal value, something of value. The key is that this contribution must have some recognized worth in legal terms, whatever you are giving. That will constitute what's called the legal value. And it has to be arrived to as a part of a bargain. We bargain this exchange. The consideration provided must be part of a negotiation or a trade-off. Each side contributing something to the table. Each side's contribution is giving an exchange for something else. It's not just about giving anything. It's about the value being part of a deal-making process. This means that the parties have engaged in some form of negotiation or mutual agreement where each consideration is offered in response to the other. So I give you this, you give me that. A simple example will be if Tom agrees to paint Mary's house and Mary's agreed to pay Tom $500 for the service, there's a consideration on both sides. Tom's service of painting of the house and Mary's the promise to pay $500 are both valuable and part of a bargain for exchange. Each is giving something in return for something else. Now, let me ask you this. Does the consideration has to be sufficient and adequate? How about if Tom agrees to paint Mary's house for $100? As long as they negotiated this price, that's fine. The exchange don't have to have of equal value as long as both parties agree to it. So consideration must be legally sufficient. It means it has some value recognized by law. However, the court does not assess the adequacy, the fairness of the consideration, unless there's an evidence of fraud, coherence, or some sort of an unfairness. So it cannot be grossly unfair or unconscionable. Let's take a look at this scenario where Emily, an elderly woman, is pressured by her caretaker, John, to sign a contract transferring her property to him. Well, Emily may not fully understand the terms because of her age or her health, or she may be coerced, forced, indirectly to do so. If John used his position of trust to influence her decision, well, the contract could be challenged based on an undue influence, lack of capacity, or even fraud, because he might be coercing her. Such defenses, if proven, would render the contract void and voidable. How about past consideration? Well, if I did something for you in the past and now you promise me something, can I hold you accountable for that? Well, for consideration to be valid, it must be for future action, not for action or services already performed, which is called past performance. So past consideration is not recognized as a valid in forming a contract. So I cannot say, well, because you did this in the past for me, I'm going to give you something and now we have a valid contract. For example, Jordan previously helped Casey move into a new home. Well, a week later, Jordan was impressed with Casey's help and agreed to pay Jordan. Let's take a look at an example. Jordan previously helped Casey move into the new home. Well, a week later, Casey was impressed with Jordan's help, and Casey promised to pay Jordan $200 for the assistance provided. Well, since Jordan's help was given before Casey's made the promise and without expectation of payment, Casey's promise is based on past consideration. In other words, it's not a valid consideration to form a contract because it's a past consideration. If Casey decided not to pay Jordan, Jordan cannot enforce the promise in a court because the consideration to help was in the past and was not part of a current exchange for Casey's promise. Now, before the help, if they negotiated this, then it will be a different story. The same concept applies for moral consideration. Let's assume Alex saved Drew's dog from being drowned a month ago. Well, that's great. In gratitude, Drew promises to pay Alex $50 every month for his heroic act. While Drew's promise is motivated by a moral obligation to reward Alex, it doesn't constitute a valid consideration in the eyes of the law. So Alex's action, saving the dog, was not done in exchange for Drew's subsequent promise. It's a good deed, but we don't have a valid contract here between Alex and Drew. It was a past act and has already been completed. Therefore, despite the moral, praiseworthy nature of Alex's deed, it cannot be considered legally enforceable consideration for Drew's promise. Also, we have to be aware of what we call pre-existing duty. So if a party is already legally obligated to perform a certain action or duty, promising to do what they are already bound to do does not constitute a new consideration for the contract. So if you promise to perform, and that's the contract, you cannot say, well, I'm not going to perform unless I get something else. An example, John, a building contractor, is under a contract with Emma to build an extension to her house for $20,000. Midway through the project, John realizes that the costs are higher than anticipated and asks Emma for additional $5,000 to complete the job. Is Emma required to pay John an extra $5,000? And the answer is no. If Emma agrees to that increase, that's up to her, but she doesn't have to. Legally, she's not obligated to pay the extra $5,000. Because why? Because John is already contractually obligated to complete the project at the agreed upon price. And merely fulfilling his pre-existing obligation does not constitute a new obligation. Now, what can be done? Well, John's initial agreement to build is a pre-existing legal duty, and his continued work does not provide a new consideration. Any modification to increase the contract price is not enforceable unless John is giving something in return. What can John give? Well, John agreed for additional work or some type of sort of an enhancement of the quality of the material compared to what was originally agreed upon. If there's any consideration being exchanged between John and Emma, then it's enforceable. Otherwise, Emma is not legally obligated because John has a pre-existing duty to do so. Another example about pre-existing legal duty is a police officer. Well, if a police officer catch a thief and you promise him a promise to pay money, and you said, you know what, I'm not going to do it, you don't have to do it because the police officer had a duty, pre-existing duty, to catch that thief. How about consideration to third party? Can you pay a third party for the consideration? Well, consideration in contract does not have always to be directly benefiting one of the contracting parties. It can involve a promise to do something or give something to a third party. It would still be a valid consideration. For example, Emily promises to donate $100 to a local charity if David agrees to help her organize her store's inventory over the weekend. So if David agrees and David says, I will help you, you gotta give $100 to a local charity. Is this a valid consideration? Yes. In this scenario, the charity, a third party, benefit from Emily's donation. However, Emily's promise to donate is still valid for David's promise to assist with the inventory. So there is a mutual agreement here. I'm giving the consideration to the local charity for David to help, and David agreed to that. It's as if Emily gave it directly to David and David gave it to the local charity. So consideration to third party, that's also considered a valid consideration as long as both parties agree to it. Let's take a look at this multiple choice questions from Farhat Lectures. Which of the following best defines consideration in a legal contract? So here we're looking at consideration. Well, let's take a look at A. A formal written document that outlines the terms of the contract. Well, this is contract formation. This is what we're looking at. Formal written document outlining the contract. That's part of the contract. Is that defining consideration? No, that's not the definition of consideration. The negotiation process that occurs before a contract is formed, that's also part of the contract formation. We have negotiation. That's not the definition of consideration. Something of legal value given in exchange for a promise. Is that considered consideration? Yes. Consideration is when something of legal value given in exchange for another promise. So I'm giving you something in exchange for something else. That's a good answer choice. Let's look at D. A promise to perform a legal duty that one is already bound to. Well, if you're already bound to do it, the promise to perform that legal duty does not define a consideration because you're already required to do so. D is out. C is the correct answer. What should you do now? You want to go to Farhat Lectures, look at additional MCQs. That's going to help you with this topic as well as other business law topic, whether you are studying for your CPA exam or taking a business law course. Invest in yourself. Invest in your career. The CPA exam is worth it. Good luck, study hard, and of course, stay safe.